Good afternoon, everyone, and thank you for joining us for today's webinar, Human Resources Compliance Trends to Watch in 2022. I'm Suzanne Sentman, Human Resources Director with McKonly Asbury. For those of you who are unfamiliar, McKonly Asbury is an accounting and business advisory services firm with offices in Camp Hill, Lancaster, and Bloomsburg, Pennsylvania. We provide a range of accounting, tax, audit, and advisory services to many of the region's well-known organizations across a variety of industries. In my capacity with the firm, I periodically assist clients with their HR-related questions. As we know, employment laws and regulations can be challenging to keep up with. The ongoing effects of COVID, coupled with the hiring woes brought about by the Great Resignation and ever-changing legal landscape, create some definite challenges for employers to work through. We look forward to covering these topics with you today. If you've joined us on past webinars, welcome back. If you haven't, our free monthly webinar series feature various business topics to keep you updated on what's going on around us. Be sure to check out our website to catch past presentations and current information through our blog, and don't hesitate to reach out if we can help in any way. Today, I'm excited to have with me our guest presenter, Rick Hackman, Chair of the Labor and Employment Group at Saxton Stump. Rick has over 20 years experience representing employers and management in all aspects of employment law. By coming together today, our firms are looking forward to bringing you the latest on HR compliance trends that we are seeing as we continue into 2022. We encourage you to visit our websites and learn more about what we do and how we can serve you and your organization. But before we dive into today's content, I do want to review some housekeeping items for this webinar. First, please know that today's presentation is general in nature and should not be a substitute for legal advice. Secondly, if you have any questions for us during the presentation, please submit them through the built-in questions function in the webinar control panel, and we will do our best to answer them during or after the webinar. Finally, we will post today's presentation on our website and social media sites in a few days. So with all that being said, once again, thank you to Rick and Saxton Stump for partnering with us today, and I'm going to turn it over to Rick. Take it away, Rick.
Thanks, Suzanne. I appreciate it. I'm sorry to say it's no longer 20 years of practicing law. It's over 25. So, you know, as we do these year to year, it gets worse. A couple things, folks, we want to talk about today. Obviously, COVID still in the forefront of everyone's mind, and then also associated with what Suzanne referenced, the Great Resignation, the issue with restrictive covenants and confidentiality agreements, and then also associated with that remote work considerations, which I know is something that everyone's running into, you know, at this time. So with respect to COVID, you know, COVID back in 2020, the Families First Coronavirus Response Act was out there requiring employers to provide paid leave to individuals who had issues related to COVID. That has since expired. However, last year, there's still been a number of lawsuits out there with respect to employers who either denied an employee leave under the prior act or continue to take some action, retaliatory action against employees with respect to leave requests. And I'll give you an example of a case that I was just involved with where an employee, while the FFCRA leave was still out there, the paid leave, the employee had to go out for his own COVID issue. He requested paid time off. During that time, the employer denied it for whatever reason. And, you know, under the circumstances, he was then made to stay home for 2 weeks without pay. Well, he continued to ask for payment throughout the course of the next several months, and ultimately they took action to retaliate against him for asking for his leave. And he, at one point, finally complained to the Department of Labor and then this employer, in an abundance of stupidity, ended up terminating him shortly thereafter. So he had a very, very strong case for retaliation under the FMLA, and ended up being successful in getting some money from his employer in that circumstance, just because the employer didn't abide by the FMLA regulations and their requirement under the FFCRA. And the other thing to consider, some of these lawsuits involve the loss of exemption. And I was just involved in another litigation matter where the employee was an outside salesperson, and in order to be designated exempt from minimum wage and overtime, that person has to spend a certain amount, the majority of their time, outside the office. Well, with respect to COVID, there were less customer meetings out of the office, and so he was pretty much stuck in the office for the duration from March 2020 up and through January 2021. So the employer then had a problem. He had no longer fell under the outside sales commission exemption from overtime and minimum wage. And as such, they owed him minimum wage and overtime because his commission payments were only paid at the end of the month, and they didn't cover what he would have been entitled to under overtime and minimum wage. So there are issues out there that employers need to be aware of. Those issues lessen as time goes on, as COVID hopefully is in the rearview mirror, but these are just a couple issues that I've seen recently.
And Rick, if I can just ask you, as far as, because throughout the presentation, we do want to, talk about best practices for employers and, what they can do, to best position themselves when faced with some of these things that you're talking about. Do you think that it would be helpful to make sure those leave request forms are updated just to have a consistent approach to how people submit those requests and make sure it's properly documented?
Absolutely, absolutely. Accurate and complete documentation is always a best practice in human resources. For FMLA requests, anything related to that, the Department of Labor provides forms on its website that employers can use with respect to certification for FMLA leave, denial or granting of FMLA leave. Employers should just use those forms. I don't recommend paying an attorney to create some form. Those forms are there for you and are available and are free. So
they're a little clunky.
What's that?
I said they're a little clunky looking, but.
Yeah, I mean, they update them periodically, but again, it covers all the bases that you need with respect to those type of issues.
Right.
And along that same line, referencing documentation, it's important to update your handbook and policies with respect to leave practices, and whether you include something related to COVID leave specifically in your policies, and how you will address that. If in fact folks are required to use paid time off or use unpaid time, if they no longer have paid time off, those are things that should be addressed within your policy.
Right, and because that FFCRA Act has now expired and the tax credits expired for employers, I did see something where it was noted that if anything, it forces employers to take a look and think about leave policies for any sort of, sick type related absence. I would like to think we're kind of coming out of COVID, but with the boosters and the shots, and if people need to take time off, I think employers just have to take a critical look at what they're able to offer up.
Absolutely, absolutely. So what's still permissible with respect to COVID and protecting employees? As many of you know, prior to COVID, a lot of these questions, you weren't allowed to go there with respect to medical questions. It was all considered a violation of the Americans with Disabilities Act. However, the EEOC came out with regulations during COVID saying that yes, employers can ask some of these questions and still not violate the ADA. For example, asking employees if they're experiencing symptoms, taking temperatures, requiring folks to stay home if they have a problem, require testing to return to work. And you may ask if anyone was in contact with someone who had COVID.
And I guess the theme here would be to make sure we're treating folks consistently. Wouldn't you agree, Rick?
Absolutely, absolutely. Because, one of the issues is, and the very last bullet point in that slide is,
Sorry.
no, that's fine, that you want to make sure that you're not just asking specific individual specific questions. You want to keep it general and you want to keep the information confidential. And again, relating back to COVID, what's still permissible? You can bar employees who refuse to allow their temperature to be taken if that's still a practice in your workplace, and bar employees who refuse to answer questions about whether they have COVID or symptoms associated with COVID. And the last bullet point there sort of circles back to what Suzanne and I discussed earlier, that because that regulated paid leave is no longer available, you can require employees to use PTO or unpaid leave in circumstances where there's been a COVID issue. Your obligations with respect to information remain the same. The information disclosed must be kept confidential. You can keep a log of temperature results if that's what you're still doing, but it's something that should only be seen by HR and then included in confidential medical records.
And Rick, I have to ask, as far as, you hear about the COVID, the unfortunate group of people who just can't get out of the symptoms, right? The continuation of COVID-related issues, symptoms, the long haulers. Do you think that that is something that would be recognized as a disability?
It's possible. That hasn't really been addressed in the law. And I mean, there's also the issue as to whether it becomes a serious health condition for purposes of the Family Medical Leave Act. If it is an ongoing issue, if it results in something that's going to substantially limit the person with respect to the essential functions of their job, it definitely could be deemed to be a disability under the ADA or a serious health condition under the FMLA. And anytime someone has residual effects of COVID, such as you hear things about myocarditis and things like that, obviously that would then lead into a disability, and it would be something that employers would have to accommodate.
So I guess the takeaway here would be, again, just going back to that, you're treating everyone consistently. You've got, good, solid practices, documentation in place. Again, if somebody's making a request under the Americans with Disabilities Act, I would say to have that interactive discussion or kick it off, you should have that request documented. Do you think that that's a good idea as well?
Oh, absolutely. You want to document requests. You should have forms in place that document requests. And then you're right, Suzanne, you need to engage in the interactive process because that's the requirement under the law. And, the EEOC and courts have sort of flipped a little bit over the years. I mean, years ago, the threshold determination was the employer takes a look, well, is this really a disability? We're not sure it is, so we don't think you're covered. Now the courts in the EEOC want employers to take less time making a determination as to whether it's a disability, and they want to know more, and they want the employer to be more proactive with respect to accommodating the individual. So the accommodation process is absolutely linked to the interactive process that you just referenced, Suzanne.
Mm-hmm, mm-hmm.
So summing up, with respect to employee complaints, I'm still having employers who are getting employee complaints about the employer not taking appropriate action to protect the workforce, such as having folks wear masks and sanitizing issues. Employers need to take those issues seriously. They need to investigate any complaints and confirm compliance, because those individuals can then report that to OSHA or some other entity, and the employer would then be subject to an investigation. And obviously, the big point at the end, no retaliation for any complaints.
Got it. And we didn't mention this earlier, but under OSHA, there is that general duty clause, right, to maintain a safe environment.
Yes.
I mean, I think any employer would want to do the right thing by keeping their folks healthy and safe while at work.
Oh, absolutely. It's in their best interest as well as the employee's best interest. I mean, absenteeism and everything associated with that. And you're right, the general duty clause is out there. I think there's some back and forth as to whether the general duty clause would cover an issue like this. And that sort of leads into our next slide, ironically enough. Well, it'll be a slide after, but let's talk about this quickly.
Okay.
With respect to COVID vaccinations, as everyone I'm sure is aware, there are exceptions to, I don't know how many folks out there require vaccinations in the workplace. You do have to provide an exemption for those with sincerely held religious beliefs and those with a medical condition or disability. And you must make that accommodation unless it's an undue hardship. With respect to sincerely held religious beliefs, if someone, you should have documentation in place for that allows an accommodation exemption form, which allows an employee to provide information as to what they believe, why they believe they should be exempt from the vaccine. As an employer, you're somewhat limited in following up with respect to exemption requests on sincerely held religious beliefs. For example, you're not entitled to have the employee, require the employee rather, to go to their pastor or priest and essentially get a note saying, well, I need a religious exemption for, you should provide Rick with a religious exemption because this is the tenets of our faith. You essentially have to evaluate as an HR person or a business owner whether that request, whether that belief that the employee expresses is sincerely held. So you're essentially in your HR capacity or your ownership capacity, making the determination as to whether you believe this individual. Now, if it's a disability request, then you may ask for follow-up information from a physician if the employee has not provided it. And again, with respect to the exemptions and the religious beliefs exemption, simply not trusting the vaccine is not a valid reason for exemption. So there are, individuals who, for whatever reason, it's their individual choice not to get the vaccine. That alone, in and of itself, does not provide for a basis for the exemption.
And one thing too, Rick, I did see where the EEOC, kind of ironic, they recognize how, the difficulties for employers when handling those religious, requests, accommodations. So there is a form out there for them that they use internally within the EEOC. So
there is, it's available.
Yep.
It's available to employers.
Yep.
And I've created forms of my own back when all of this sort of ramped up. So back to what we discussed just a minute ago about OSHA and the general duty clause. I'm sure employers are aware of what's been going on out there with respect to the government mandates and the fact that the emergency temporary standard issued by the Biden administration has been vacated and OSHA has withdrawn that. So it's no longer applicable. So employers are not required, private employers, non-healthcare employers are not required to have employees vaccinated. Healthcare, it's a little different. That mandate still applies and is going forward. With respect to those who are federal contractors, that mandate was sort of the initial mandate way back when, but that has also been stayed at this point and sort of in legal limbo.
And Rick, I know you don't have a crystal ball, but do you think that I know that OSHA has publicly stated that they're essentially regrouping and they still believe in that that mandate or that ETS rather. So any thoughts on what the future might hold there?
Yeah, I don't have a crystal ball, but I am psychic. So I can tell you that I would highly doubt that anything else will come of it. So this was issued as an emergency temporary standard. I guess the question is, how long is there an emergency? It's been 2 years now. Things have somewhat quieted down, not totally eliminated. will OSHA take any further action in this regard? Because if it is just a general statement from OSHA about, let's say, not directed to COVID, but handling pandemics or some other life-threatening illness, it's going to be hard for them to push something through in that respect. And even if they do, it's not going to happen in 2022. So it would be somewhere down the road.
Okay.
So switching to restrictive covenants, and I'm sure everyone's dealt with restrictive covenants, being either having them themselves as an employee or requiring employees that work for them to sign a restrictive covenant. And it's becoming only more and more important with respect to what Suzanne referenced initially, the Great Resignation, the mobile workforce, people moving job to job. And restrictive covenants are a very important part of your business. I mean, it protects your assets, goodwill, and the fact that you've taken time and effort to generate business and land certain customers. And so you as a business owner or as an executive or as an HR person have an obligation to assist the company in protecting those assets. And with respect to the restrictions, there's three primaries here: non-competition, non-solicitation, and confidentiality agreements. So I get the question all the time, well, we can have them sign a non-competition agreement, but they're not enforceable, right? They are enforceable, and it depends on who writes them. I see many on an ongoing basis that aren't enforceable because it's something an employer, a smaller employer, maybe pulled off the internet, and it's not narrowly tailored to their business or to the specific region. So non-competition agreements are valid and enforceable in PA, but the courts take a close look at them and view them as a restraint on trade with respect to an employee's ability to earn a living. So essentially what that means is the courts don't want to take employees completely out of the stream of commerce with respect to their chosen vocation. So if someone's been doing the same thing for 25 years, the courts don't want that individual to be so limited in their future employment opportunities that they have to go from, maybe a custom cabinet maker to working at Target. I mean, they want that person to use the skills and the experience they had in their own prior vocation to be able to earn a living.
So I'm hearing you say it has to be reasonable.
It does. And there's a couple, with respect to how you define reasonable, there's a couple different elements. For purposes of non-competition agreements, specifically, the agreement must be incident to an employment relationship. So what this means is, best case scenario, you have someone sign a non-competition agreement, a restrictive covenant of some sort at the time of employment. If you do that, you're not required to provide anything additional in the way of consideration, meaning compensation or bonus or anything else like that. The employment itself at that point is sufficient consideration for the agreement. Now, if you take action, if this person's been there for a year and all of a sudden you realize, oh, whoops, they have a lot of contact with our high-level customers and a lot of access to confidential information, we really ought to get them to sign a non-competition agreement. Well, at that point, you can't just say, here, Rick, sign this and assume that it's going to be valid. You need to provide additional consideration. So do you give them a raise? Do you give them a bonus? It has to be something along those lines. And simply giving someone, $100 to sign a 2-year non-compete is not going to be deemed to be sufficient consideration at that point. It would need to be something, I don't want to say substantial, but quasi-substantial, something meaningful. Maybe that's the right term. Now, as far as signing at the time of employment, the other thing I would just mention is it doesn't need to be necessarily by the first day of work. I mean, as long as you advise an employee in their offer letter or prior to them starting work that, hey, just so you're aware, you're going to have to sign a non-competition agreement before you start. If it's a week after they start, 2 weeks after they start, they don't sign it until then, but they have prior notice, that's still going to be considered to be signed at the time of employment. The second element with respect to non-competition agreements is it reasonably necessary for the protection of the employer's business interests? What's the specialized field you're trying to restrict the employee from? What's the position of the employee? Is this person in the mailroom or is it a high-level executive? A mailroom employee's non-competition agreement is never going to fly. It's never going to be deemed to be valid. And then make the determination, and I'll talk about this a little more in a minute, how much will it hurt if the employee leaves? I mean, will your business be crippled? What happens if that employee leaves and takes, your top customer? Those are all things you need to evaluate before making the decision as to whether to have someone sign a non-compete. And then finally, the restrictions must be reasonably limited in duration and geographic area. So where do you do business? So if you're only doing business in Lancaster County and you write a non-compete saying that, well, you can't work for anyone else in the world or on planet Earth, you're going to have a tough time enforcing that non-competition agreement. Now, I will say that, best practice in this case would be Mid-Atlantic region. If you're a Lancaster County or Dauphin County employer, Mid-Atlantic, Pennsylvania and contiguous states, Maryland, Delaware, Ohio, New York, those type of things. Limit it to the area that you believe you would be most hurt if that employee left or where those most important customers are. That's not to say that you can't have a non-competition in place that's broader geographically. I have many clients who have operations nationally and internationally, and we have drafted and required employees to sign non-competition agreements that restricts them from competing nationally. But it's got to be narrowly tailored. It can't just be, nationally. It needs to be limited perhaps to certain clients or certain specifics related to the employer's industry. With respect to length of restrictions, it depends. I mean, if you put a 6-month non-competition agreement out there, it's going to be found to be enforceable from a time standpoint. Once you get above 3 years, courts are going to start to look at that with sort of a jaundiced eye and say, well, based on what Rick does, it's really not that critical that you have a 3-year non-compete. Essentially, courts want to give an employer time to get their ducks in a row when an employee leaves. And if the employer has a non-competition for a year, it's assumed that that's sufficient time for them to draw their customer base together, make sure the customer meets or client meets the person who's taking over the account or the interaction with that person.
So time to hire or train talent.
Perfect, exactly. Now, I just want to make folks aware there are several states that prohibit non-competes. In Nevada, for one, if you have an hourly employee, you cannot have them sign a non-compete. It won't be deemed enforceable. In Oregon, anything over a year is not going to be deemed enforceable. And likewise, if they're making less than $100,000 a year, it will not be enforceable. Illinois has similar restrictions. DC, there's no non-competes allowed, period. California, no non-competes. And I'll throw in Massachusetts. If you have a non-exempt employee, meaning for the most part an hourly employee, a non-compete for that employee will not be deemed valid. And also if the employee is laid off or terminated without cause, the non-compete will also be deemed invalid.
So there are protections out there in certain states for employees.
There are. And then finally, as far as non-competition agreements, President Biden, this was towards, I guess, the middle or beginning of 2021, issued an executive order on promoting competition in the American economy. It's going nowhere. Essentially, he asked the FTC to limit the use of this type of agreement and look into it. Nothing's happened, nor do I think anything will happen. So why did I mention all these other states? Because none of them are obviously Pennsylvania. It circles back to the whole issue with the mobile workforce. You have individuals who are working remotely. Some of them may be in the states that I just previously mentioned. So even if you have them sign a non-competition agreement and you're based in Pennsylvania and the agreement itself says Pennsylvania law governs, courts frequently overlook this and apply the law where the employee works. And I had this very situation several years ago where I had a Pennsylvania employer who had their employees sign a non-competition agreement. They had 2 employees who worked in California and left and started immediately competing with their primary competitor. And we tried to enforce the non-competition agreement, but the court in California said, no, we're not going to enforce that because this employee's primary contact was with California. We tried to get around it by arguing, well, they spent X number of days in Pennsylvania, they met with people in Pennsylvania on an ongoing basis, and otherwise trying to make a case that there were sufficient contacts with PA that PA law should apply. But California decided otherwise.
Interesting. So I guess it just adds another layer for employers to think about as far as, keeping up to date with specific state law, especially with the remote workforce, if somebody moves.
It does, and that would be the time to look at what you have in place. Well, okay, I have this non-competition agreement in place with Rick, and he's currently in PA, but he's moving to Las Vegas. And I know Nevada has certain limitations on non-competes. And so how do I structure that with Rick moving to Las Vegas? So non-solicitation agreements, sort of the sister to non-competition agreements, these are absolutely enforceable and courts do not scrutinize them as closely. I mean, courts take the position, as they should, that an employer has the right to protect direct solicitation of their clients and customers. So if an employer has worked hard to get McKonly and Asbury as a client, and they put a lot of work and a lot of time into that, the employee should not be permitted to directly solicit McKonly after they leave. And lastly, confidentiality agreements. They are absolutely enforceable. You can't have confidentiality agreements, though, that are so broad as to be sort of unintelligible, I guess. So something simply saying all confidential information of the company is protected and you can't disclose it, that's not going to cut it. The courts have said you have to be specific and identify what you're trying to protect. So you want to have a laundry list there of things that you deem to be confidential. So it should be, your list should be including, but not limited to, customer lists, which are protected trade secret in Pennsylvania, by the way. Client information, if you're a healthcare provider, patient information, financial information, marketing documents, go through the list and specifically identify what you as an employer deem confidential. So there's no confusion at a later date as to what is confidential and what is not confidential. Even if you don't have a confidentiality agreement in place, employers do have protection under the Pennsylvania Uniform Trade Secrets Act. 2 things with respect to the act. If a given piece of information is readily known or can be easily obtained by others, it's not a trade secret. So even though you have something that you may think is confidential and proprietary, if I can go out on the internet and find it, it's not going to be deemed a trade secret, even though you think it might be. And the second part of that, if the converse to that is that if it's not readily known or ascertainable, and you as a business or as an employer have done something to keep the information secret, then it generally is considered to be a trade secret. So what does that mean as far as keeping it a secret? I mean, it doesn't, you don't have to go to the extent like the formula for Coca-Cola, but it should be a situation where it's password protected. You know, it's on a specific drive that only certain employees have access to. And that's further defined here in what the Trade Secrets Act actually says, something that derives independent economic value from not being known. So it's something that you've used to build your business. And it can be not only your trade secret, but maybe it's confidential information provided to you by a client that they deem to be a trade secret. And it's subject to efforts that are reasonable under the circumstances to maintain secrecy. So again, what does that mean? Password protect information that you deem to be confidential. Put it on a separate drive and allow limited access to that drive. Under the Pennsylvania Uniform Trade Secrets Act, you know, with respect to bringing a cause of action under that law, employers are required to show that it was misappropriated through improper means. In other words, Rick did not have access to that drive, but somehow he gleaned Suzanne's password and used Suzanne's password to get into that drive to view the information. You know, what damages did you as an employer suffer? Was there an actual loss? Can you put a number on it? So you bring a lawsuit because you lost your best client. You can put a number to that. Well, this is the amount of business we did in the last 2 years with this specific client. You know, it was $200,000. And because our trade secrets were taken and used to woo this former client, we're now out an estimated $200,000. You can also get injunctive relief. So in other words, if you know I took a trade secret, you can go to the court and say, court, we want you to stop this immediately. We're demanding an injunction to put the brakes on any further actions by Rick, who took our information. There's potential punitive damages, meaning damages punishing someone for taking it. And the other important thing with respect to the Pennsylvania Uniform Trade Secrets Act is that victorious or successful employers can get their attorney's fees paid, which is one of the few prevailing attorney's fees provisions under the law. So that's also a consideration when bringing a case. Well, do we have a strong case? You know, if we do, we can get our attorney's fees paid, so maybe it makes sense to go forward. The litigating non-competes, and I'll tell you, in the last 5 years, there's been a lot. I've had a lot of this. I've had more in the last 5 years than I had in the prior 20 years of practice. The problem is they're expensive to litigate and it's difficult to prove damages. Now, I mentioned before, if you can show an actual loss of a customer or something related to that, then that's great, but that is not always the case. In a breach of a non-compete does not always equal victory. So damages are a component of any lawsuit. So you can certainly show that in violation of my non-competition provision, I went and competed by setting up my own business in the geographic area upon which I was restricted. However, you still need to show as an employer how you were damaged by that. So a simple breach does not always equal a victory. And then, you know, it's hard to put direct values on all of these issues too. You know, what's the value to you as a company of loss of confidential information? And they're long cases. It's a long, expensive process. I just last year wrapped up a non-compete litigation that lasted 5 years. And that was a situation where there was clear competition. We could prove exactly that the individuals who left the company took confidential information and began competing in violation of their agreements. However, the problem was showing damages. How did we come up with a damage calculation? And that was our biggest hurdle in the case. So when litigating non-competes, you want to be smart. You want to take a circumspect approach. Start out with a cease and desist letter, and then undertake a cost-benefit analysis. Talk to your attorney. How much is this going to cost us if we move forward in litigation with this matter? Now, any attorney, including me, will say, well, it depends. And it somewhat does depend on who you have on the other side as far as counsel or as far as a defendant. Is it going to be problematic to deal with? Is it going to run up costs? So you want to weigh the cost of litigation against the cost of the loss. So if you think they took a piece of information that you value at $20,000, then it's probably something that you as an employer are going to have to move forward and accept as a loss, because it's going to cost you more than $20,000 to litigate that. But there are soft costs or soft issues too. You want to send a message, and I have employers who do want to send a message. They don't care that it's going to cost money. They want to have a shot across the bow, so all employees are aware that they take these things seriously, and they're going to go after individuals who violate their non-competition agreements. Just a brief note here about acquisitions and having those type of non-competition agreements in place. If it's a stock purchase and the acquired company maintains a separate existence, the non-compete's unaffected. The surviving company can still enforce the agreement. It's less clear, however, when the company disappears due to the merger. In PA, courts want to see that non-compete clauses and agreements are specifically assignable. So it's important to have provision like that in any non-competition agreement that you have someone sign. So ultimately, avoiding problems, again, be reasonable in the restrictions. That goes to both duration and geography. You could even go as far as to make it specific, saying, well, Rick, I don't want you to compete with, you have a non-competition agreement in place, but it's only for the following companies we deem to be competitors, and you list those companies. Clearly define confidential information and include an assignability provision. Remote work, which is on the tip of everyone's tongue, and it's something here even at the firm that we're dealing with now. We were mostly a come into the office firm before, but we do now have significant remote capability, and we allow employees who request to work from home, and I myself work from home on occasion. It is a new reality, and it's not only with respect to current old dogs like me, but the younger generation sort of expects the flexibility in being able to work from home on occasion. So it's something that we all have to recognize. We have to recognize that, hey, there is going to be productivity for someone who works at home. When we went in March 2020, when we converted to our remote firm, our production, we barely had a blip during the time we were out of the office. We were out of the office from March 2020 through June 2020, and our productivity for the most part stayed the same. If you're considering allowing remote work, or you do allow remote work, it's important to have a written agreement in place. And you can go. Sorry, go ahead. You can have a written agreement in place, and because some of the things that you need to make sure that you identify are specific issues that may arise. Fair Labor Standards Act, wage and hour violations. If someone's working from home, it's difficult to determine how many hours they're actually working. Are they like me, that they're throwing in a load of laundry during the course of the day and things like that, or walking the dogs, something along those lines. Tips for making sure that employees are being paid for hours worked, and the fact that they are actually working those hours. you want to make sure that the time records submitted are absolutely certified or reviewed by the employee.
And I just wanted to, if I could just kind of say,
Yeah.
Rick here, I know that these next several slides, I think they're jam-packed with some, takeaways and pointers for employers, just to, as they firm up expectations and create those policies to try to be as comprehensive as possible. So I just wanted to kind of say that because I know these next several slides really cover a lot of ground.
They do, and one important thing, and it was something that we ran into as well, is prohibiting employees from working off the clock and prohibiting managers from demanding that employees work off the clock. So, what does working off the clock mean? Well, we had a situation. We obviously have paralegals at the firm, and paralegals are not exempt employees. They're not exempt. They have to track their hours. But many paralegals could get their firm emails on their smartphone at home. So you would have situations where paralegals, like everyone else, sort of wants to be on top of everything for the next day, reviewing and responding to emails, after hours. That's all deemed to be hours worked and must be captured and compensated for. So, we as a firm have made it clear that you need to write down any hours. We do not require you to review or respond to emails after hours, but in the event that you do, you need to make sure you capture that time because you're entitled to be paid for that time.
So if you switch out your laundry over lunch and you're checking your email, not a good idea.
Well, I mean, if you're checking your email while you're switching the laundry, then you're going to be paid for it if you can multitask like that. So, how do you govern this? How do you make sure it doesn't happen? You want to train managers and hourly employees at periodic intervals. You want to just communicate this information to them and make sure everyone understands that here are the guidelines with respect to these type of actions. If you have supervisors and employees who are not accurately capturing time, working off the clock, you need to speak with those individuals and ultimately discipline those. So if I'm working for you and I'm a non-exempt employee and you've told me several times, do not work after 5 o'clock, and I work after 5 o'clock, work till 5:30, then you as the employer are required to pay me for that extra half an hour, but there's nothing to prohibit you from disciplining me. Because it's simple as, listen, we told you that not to work after hours. We are going to compensate you for that time, but because you did, you're being written up. And if it happens again, you're fired. So your obligation as employer is to pay for that time. But again, that doesn't restrict your right to discipline them. The work environment obligations. So if you have someone working at a home office, in some ways, that's considered an extension of your workplace. And the same issues arise in this extension of your workplace as they would in the actual workplace. So you're thinking about workers' compensation issues. Just because they're not in the office doesn't mean you're not responsible in at least some way for their safety. And so I have clients who do, okay, Rick, we want to see your homework office. We want to come out and make sure it's all, essentially free from clutter and everything's, up the code and it's all set up perfectly. Because again, you may, as an employer, have a workers' compensation issue if I'm working from my home office and something happens while I'm in my office, because again, it could be an extension of the actual workplace. Data security concerns is a big one. I mean, do you have proper electronic security in place? And I'll talk about that a little more in a minute. Something as simple as proper disposal of paper. Now, we have documents here that need to be shredded. I mean, is that the case with this employer? Are they handling sensitive documentation? Do they have the ability to shred it immediately? Because obviously, if the home office is accessible to members of the family or visitors to the house, that stuff can get out. It can be disclosed if it's not properly handled. Another one last consideration, sorry, on that slide, and this sort of relates back to the wage and hour, and it was probably more appropriate there. If some employees work when the company isn't open, so I know some people had off for President's Day. If those people work from home during President's Day, even though it's a firm holiday, they should be paid for that. So it's important to clarify what's expected of remote workers when there's a firm holiday. Eligibility, be out in front of this, determine now, what positions you deem to be eligible to work remotely. Obviously, if it's a factory situation, you can't, make the widgets from home, so that you want to state up front whether the position for which you're hiring is remote or potentially remote. If you take care of this on the front end, it's not going to come back to bite you in the back end.
I think that could also help too if you get potential ADA requests or accommodations.
It absolutely does. It absolutely does, and that's a great point. And probably ought to be even flipped into the job description, because it's an essential function of your job that you work in the office every day, that you work on the factory floor every day. So then if they come back and say, well, I really need to work at home for X, Y, and Z reason, you say, well, the essential function of the job is that you're in here every day. So that is not an accommodation we can make. You ought to communicate, I'm sorry, back up.
Sorry.
No, you want to communicate the availability and your expectations as an employer as far as responsiveness, and as far as what the hours are. Are they supposed to be in front of their computer 9 to 5, or is there some sort of flexible schedule? And make it clear that remote work is not substitute for daycare. And I know it's a struggle for some parents with respect to childcare, especially now, but there has to be clear outlines and expectations and obligations as far as what's going to happen during the course of the day with respect to the employee's work. How are employees supposed to respond when they receive requests? Is it immediate response? Because again, you're not walking into someone's office. I mean, it's going to be a situation where you Teams them, or you email or text or whatever it may be. So you need to identify what the mode of communication for response is, and what's the expected response time. And then how do you measure productivity? And there's certain ways that can be done. If it's simply the work product performed and provided by the employee, it's easier than in some circumstances where it's much harder to measure that.
And I would suggest too that employers, lean on their frontline, I'll call them frontline supervisors, right? Those supervisors who manage, the day-to-day activities of employees. I think for those supervisors to define those expectations, what the job entails. I think kind of going back to your earlier point, Rick, about responsiveness, you can prevent somebody from maybe responding off the clock, right?
Right.
So I think having that supervisor have those conversations, define those expectations, lay everything out, I think that can only help the employer overall.
Remote work equipment. What equipment will the company provide? Is there a reimbursement? I mean, these are all the issues you need to identify going in. What equipment will you provide? Will they be reimbursed for supplies? How does that all work? And also, if you are providing equipment, you want to make sure you have something in writing that says if they're terminated or resigned, they're required to return that equipment within X number of hours or days. So you want to make it clear that, hey, this is company property. In the event your employment is terminated or you resign, you're required to return this property within 24 hours under the penalty of death or some very strong language.
Oops, I think I skipped one.
Yeah, that's all right. So other challenges, sort of it's not the right phrase, we'll call them softer challenges, are, the whole work-life balance. It's either employees are spending too much time working and thinking about work or not enough time. And I had the same situation here. I have partners who, enjoyed working from home and, getting things done within a certain time period and were very productive. And then I had other partners who said, yeah, I really didn't like working from home because I didn't know when to stop. I'd be, it wasn't sort of, I had more of a start and stop time when I go into the office, but when I was home, I was, working at night and things like that. So I really prefer coming into the office. So try it. If this is something you want to do, offer a flexible work policy. Say, hey, you're allowed to work from home 2 days a week. Come up with whatever scenario works best for you. Security issues, I said I would circle back to this. I mean, remote work opens you up to a whole host of different threats, viruses and ransomware and such. And so make sure your IT department is tuned in to the equipment used by the employee and make sure everything is up to date with respect to virus software and everything associated with it. And cybersecurity training, because it's huge. We have a whole cybersecurity department here because we get constant requests from clients about cybersecurity issues. Other challenges are sort of this physical separation of the workforce, and it's getting less and less now. This would have probably been a more appropriate slide a year ago because there was still a lot of people that were not working in the office, and now it's sort of been overcome a little. People are returning to the office, and people are now, more comfortable, more familiar with video conferencing and things along those lines, which, in many cases, with respect to the type of work folks do, you need that collaboration. You need the back and forth between your colleagues with respect to creativity and sparking new ideas and things along those lines.
Yeah, I mean, where you might have maybe bumped into folks, down the hall, or, had a casual conversation that then turned more into a collaborative sort of effort. I think when you're remote, you have to be very purposeful with, making sure you're staying in touch with each other, right? And building those connections.
Absolutely. It's the old water cooler that, people gather around the water cooler to talk about activities, not only work activities, but personal activities. And so, that's one of the things obviously that's missing. Now, when I talk to a couple of my partners, it's never about anything worthwhile. It's mostly about sports. So it's probably better if we're working remotely so we're not wasting each other's time. But productivity, and it's always a struggle. Again, are you as an organization happy with the level of productivity for those individuals who are working remotely? Some ways to make sure that productivity stays high, regular contact with staff, clear targets, absolutely. Let's put out what the targets are, make sure the employee understands it. And then there is performance and activity monitoring software, if that's something of concern, that you can have installed on the employee's computer. And this sort of circles back, I think, to one of the prior slides, the social element of the office. It's a challenge. I mean, Teams and Zoom can assist, but it's not an absolute substitute. So if you're a company who takes pride in its culture and pride in its employees and employee interaction, it does make it difficult when you have half your workforce working remotely. And online social events, aren't the same as in-person social events.
Definitely. And we look forward to more in-person social events. I can tell you that here at McKonly, for sure. It is good to definitely be with everyone. So, unless we have any questions, I know we're closing in on the 3 o'clock hour here.
Yeah, and I believe that was the final slide, so we're right on time.
We are.
Again, if anyone has any questions, please submit. We're happy to answer them.
Yep, I see that we do not have any questions, but if anything would come up, you have our contact information on this final slide here. And as we mentioned earlier, definitely we'll have that recording available. It'll be posted on the website and our social media sites. We'll have that up in a few days. And with that, we thank you for your time. I hope you found it to be time well spent with some clear takeaways for you and your organization. And on behalf of McKonly, thank you for joining us. I hope you enjoyed the rest of your afternoon.
Thank you very much.
Thank you, Rick.